Thank you very much, Mr. Chairman. A couple issues I want to address. One, I mentioned before the letter from Director Rodriguez of February 26, 2015 that we've already entered into the committee hearing record. In that letter, Director Rodriguez stated that Secretary Johnson reiterated his instruction in a memorandum to the heads of the relevant DHS components in terms of how to comply with the district court's order. And I'd like to ask the witnesses here to provide that memorandum to the committee to be entered into the record so that the committee can see the written instruction that the component heads have been given.
Yes.
Thank you very much. I want to shift topics to the question of fees and a couple of different aspects of it. Number one, Mr. Moore, as I understand it, USCIS's position is that various immigration fees can be allocated. Let's set aside the district court injunction for a moment. But prior to the injunction, it was USCIS's position that certain fees could be allocated to implement DACA and DAPA, absent congressional authorization. And there are a variety of fees, including the immigration examination fee account, the immigration user fee account, the H-1B non-immigrant petitioner account, the land border inspection fee account, the fraud prevention and detection account, the premium processing fees, and all of these are enumerated in Title 8 of the United States Code, Section 1356. The first question I'd ask of you, Mr. Moore, is roughly how much money does USCIS have at its disposal via the immigration examinations fee account and these other accounts and fees?
Thank you for the question. Managing a fee-based operation the size of USCIS is complex with many different fees. We have set as a condition of protection for us to retain at least $600 million annually as our cash reserves. The one thing that we recognize is that USCIS in many ways operates very much like a commercial enterprise. We get money as it comes in, and we have to manage our expenses related to that. At the beginning of a year, when we're anticipating spending up to $3 billion, much of that is what we call anticipated collections. So as we're spending, we're taking in new fee revenue. Our permanent indefinite appropriation allows us the authority to immediately access those fee revenues. We still do work with Treasury to get money warranted and with OMB to have a portion to us, but all of that happens quite seamlessly in the immigration examinations fee account. So we have a very detailed operating plan that we use to identify our agency spending, and so that operating plan ensures that we're maintaining that reserve. And I want to just mention that the fee account, as I mentioned in my opening statement, is subject to fluctuations, normal course of business, and the fee structure allows for those surges in workload to bring in fee revenue that allows us to promptly address that.
So how much money are we talking about?
In our reserves? So, as I said, we had last year in total in our examinations fee account about $1 billion carryover balance, and that was between premium processing about $734 million and the balance, or excuse me, non-premium processing of $734,000 and about $460 million in premium.
Now you stated in a letter to the chairman that those funds can be used for the purpose of processing DAPA and DACA. Do you see any statutory language whatsoever in Title 8 United States Code Section 1356 that allows those funds to be used for those purposes?
So, Senator, thank you for that question. I defer to our legal counsel to guide us on the lawfulness or the appropriateness of programs and initiatives as far as expending our immigration examinations fee account. And so I rely on that.
But you can't point to any statutory language here today, is that correct?
I'm not qualified to make that kind of determination. Again, I work with our legal counsel who gives me advice and assures us that in their view it's legal. So if I am moving forward with authorizing spending within our agency, I'm doing so with the confidence that it's legal action based on counsel that I'm receiving.
Well, I would note your legal counsel is apparently authorizing you to spend money that is not authorized by statute. I would also note the position of USCIS that there is over $1 billion in unregulated funds that is not subject to Congress's authority and can be spent independent of the appropriations process is something, it seems to me, Congress should correct in this upcoming appropriation cycle so that USCIS operates like any other agency of this government, pursuant to appropriated funds and not with your own bank account. Let me shift to a different topic with the chairman's indulgence. One of my many concerns with the president's executive amnesty, my first concern is that it is contrary to federal law and unconstitutional. And as I noted earlier, a federal district court has agreed that it is contrary to law and has accordingly enjoined it. But another major concern is a question of fairness, that executive amnesty benefits and in fact gives preferences to those who are here illegally, and it does so to the detriment of legal immigrants, of those who have followed the law and come here legally. I am the son of a legal immigrant who 58 years ago came here, applied to come here legally, and ultimately received U.S. citizenship. It was reported in the Los Angeles Times that the DACA program was expected to cost between $324 million and $484 million over the next 3 years. Is that an accurate projection?
Yes, sir, that is based on internal cost estimates.
And that means somewhere between $324 million and $484 million that would otherwise be spent to aid the processing of legal immigrants is not being spent for legal immigrants, and so their wait times are going up, the bureaucracy is going up, their burdens are going up. Is that accurate?
Senator, not quite. The fee associated with a DACA expansion DAPA applicant, $380 for the employment authorization document, $85 for the biometrics, was part of the filing requirement, and we estimated that through those requests with the associated fee that it would yield the kind of revenue that you quoted, so that we believe that the individuals applying for deferred action would in fact pay the cost of the program without us having to borrow from others.
Well, I'm glad you brought that up, because you described the $380 I-765 fee and the $85 biometric fee as somehow a fee for DACA and DAPA, but is it correct that those apply to everyone, not specially DACA or DAPA?
Those are the fees that are associated with the DACA original.
But they're not specifically DACA and DAPA, are they? Are there non-DAPA or DACA applicants who pay those fees?
No, sir. Not in the combination of, well, let me rephrase that. We packaged the Form I-821D and the I-765 together as a filing requirement. Only DACA, DAPA applicants are filing those documents as a package.
So the I-765 is not paid by anyone who is not a DAPA or DACA recipient?
No, the work authorizations are issued according to other adjudicative actions that they would pay that fee, correct?
So it goes back to what I said. Everyone's paying that fee. That's not a special DACA, DAPA, and let me just underscore this. So, for example, the I-140, the Immigrant Petition for Alien Worker, It's $580. That's someone coming here legally to work. A DAPA or DACA person pays $0. Now, they both pay the $360 and the $85, but in terms of the fee for the application, someone following the law is penalized and is paying, in that instance, $585 versus $0. Is that correct?
Senator, I think the DAPA and DACA applicants, we are charging the $365, or $380 to cover the cost of processing their request. The individuals filing the I-140 are applying for a separate benefit, and they are paying an associated fee for that. So there isn't an overlap.
All right, let's give another example, which is the I-5.
It's the same amount of money. It's the same amount of money, right?
The same fee, I-765 fee is correct. That's the same fee across the board.
The I-526, the immigrant petition by an alien entrepreneur, costs $1,500. So someone wants to come here, start a business, create jobs. We say, thank you very much, write a check for $1,500. Someone who came here illegally, broke our laws, and is applying for DAPA or DACA, we charge them $0. Is that correct?
Senator, we calculate our fees based upon the level of effort that's required to review and process each form type. We use activity-based costing to do so. So if the cost is much higher for that
Let's give one more example, which is the I-924, the application for regional center under the Immigrant Investor Pilot Program. An immigrant investor putting capital to work to create jobs at a time when we have the lowest labor force participation since 1978. We charge that person $6,230 for the privilege of hiring Americans and creating jobs. Those who come here legally are being penalized, and yet those who come here illegally are facing a fee of $0 to be allowed legal status. Does that strike anyone on this panel as remotely fair?
Senator, we do charge a fee for the DACA-DAPA program. It's not free. There is the
$380
yes,
and the $85 are paid uniformly by everyone. So that's not a special fee for DACA and DAPA.
no, but it is a fee that they're paying. It's not.
So they're paying one of the fees, but everyone else coming legally pays an additional fee, except those here illegally. I have to say, I cannot think of any other fee program, any rational fee program that allows those who break the law to be exempt from paying a fee, but if someone is foolish enough to actually try to comply with our immigration laws, to wait at home, to wait in line for years, sometimes decades, we smack them with a fee of $1,500 or $6,200, but those who are here illegally pay nothing. That strikes me as a program that is indefensible to the American people. Thank you, Mr.
Thank you.